promote the right to self-determination of the Sahrawi people. Our meeting today, in the wings of the 52nd session of the Human Rights Council, which, let us remind ourselves, is commemorating the 75th anniversary of the adoption of the Universal Declaration of Human Rights and the 30th anniversary of the Vienna Declaration of Programme of Action, provides us, and more specifically our distinguished panelists, with an opportunity to analyze the current situation, to identify the systematic violations of human rights, violation of these two covenants, and the illegal exploitation by foreign enterprises of the natural resource wealth of the Western Sahara. Our panelists will help us understand the mechanisms used by these multiple actors in the occupation of Western Sahara and in the illegal exploitation of its wealth. So, colleagues, we look forward to an instructive and productive session. Once again, our warm thanks to all those who have joined us, both here in the room and online. And allow me now to once again thank Her Excellency, the Deputy Minister of International Relations and Cooperation of the Republic of South Africa, Honorable Ms. Mashego Dlamini, for honoring us with her presence. We invite her to address our conference. Excellency, you have the floor.
Thank you very much, Your Excellencies, distinguished guests, distinguished panelists, ladies and gentlemen. It is my sincere honor to be able to say a few words today at this side event arranged by the Geneva Support Group for Western Sahara on the implementation of the Article 1 International Covenant on Civil and Political Rights and International Covenant on Economic, Social and Cultural Rights in the Western Sahara. Your important discussion today seeks to propose measures states should take to meet their obligation towards the non-self-governing territory of Western Sahara under Article 1, Paragraph 3 of the ICCPR, namely to promote the realization of the right to self-determination and respect that right in conformity with the provision of the Charter of the United Nations. As you are aware, Western Sahara has been on the decolonization agenda of the United Nations for more than 50 years and has been occupied by Morocco for 47 years. A plethora of UN Security Council resolutions have been adopted calling for the permanent sovereignty of the people of non-self-governing territory, including the people of Western Sahara, in accordance with the relevant resolution of the United Nations on decolonization. The United Nations Security Council continued to meet and adopt resolutions to extend the mandate of the peacekeeping mission, MINUSO, mostly recently until 31 October 2023. As MINUSO was created to oversee a referendum in Western Sahara, its mandate is weak, as inter alia has no authority to monitor human rights violations. Over the past years, the repression extended by the Morocco occupying forces against the Sahrawi civilian population, notably human rights defenders, journalists, and political prisoners, has dramatically increased, including with the use of modern technologies, such as drones, to strike indiscriminately at selected targets in Western Sahara. The human rights situation in the Western Sahara continues to be a major concern for the international community, and repeated calls for the strengthening of MINUSO's mandate to include the protection of human rights have been made to global. Successive special envoy of the UNSG for Western Sahara has failed to broker consensus from Morocco to allow for a credible referendum to be held, and the fact that UNSC Mr. Antonio Guterres took more than 2 appointed Mr. Stefan de Mistura as his new personal envoy for Western Sahara, followed the resignation of his predecessor, Horst Kohler, in 2019. Further stayed the process, particularly access to the occupied territories of the Western Sahara. We are well aware that the United Nations High Commissioner is constantly requested by this support group to report on the situation of human rights in the occupied territory of Western Sahara at each session of the Council, and to resume the technical mission to Western Sahara that was last on the ground in 2015. Such a mission certainly is yet to be undertaken. Your Excellencies, please be assured that the government and the people of South Africa are determined to support the Sahrawi people in their struggle to exercise their inalienable right to self-determination, a right that international community has solemnly recognized for the people of Western Sahara on 3 specific occasions. We look forward to the valuable contribution for the panelists this afternoon, in which the Geneva Support Group on Western Sahara, as well as the NGO Support Group on Western Sahara, all encouraged to continue to support the Sahrawi people of Western Sahara in their struggle for self-determination, and to be able to have control over their own national resources. I wish you all the fruitful deliberation. I thank you.
Thank you very much indeed, Excellency. So I thank on behalf of us all here, with those online, I thank Her Excellency, the Honourable Deputy Minister, for her thoughtful statement and for setting both the context and the tone for our deliberations today. Let me end my own comments here now in the interest of time, somewhat limited. And let me hand the floor to our moderator, Mr. Gianfranco Fattorini, to lead us through our program today. I thank you all for your kind attention. Over to you. Thank you.
I thank you, Excellency. And as Ambassador Combat just said, this conference will focus on the application of Article 1 of the 2 covenants in Western Sahara, and in particular paragraph 3 of Common Article 1 of the International Covenant on Civil and Political Rights and of the International Covenant of Economic, Social, and Cultural Rights. Paragraph 3 says that states parties to the present covenant, including those having responsibility for the administration of non-self-governing territories and first territories, shall promote the realization of the right to self-determination and shall respect that right in conformity with the provisions of the Charter of the United Nations. In its general comment number 12, 1984, the Human Rights Committee stressed that paragraph 3, I quote, in the committee's opinion is particularly important in that it imposes specific obligations on state parties, not only in relation to their own people, but vis-à-vis all peoples which have not been able to exercise or have been deprived of the possibility of exercising the right to self-determination. The distinguished panelists will highlight the contradictions between the obligation arising from Common Article 1 of the 2 covenants and the policy they implement by a number of states that support the illegal occupation of Western Sahara by the Kingdom of Morocco. And without further ado, I give the floor to the first speaker, Mrs. Aleidis Nissen. Mrs. Nissen is a postdoctoral researcher at Leiden University in Netherlands. She is the author of a book that is being published in November 2022, titled The European Union, Emerging Global Business and Human Rights.
So much. Okay. So so much for the introduction. Indeed, my expertise is in corporate human rights violations, and I'm really glad that I can contribute today. So here's my take. Morocco, while occupying the Western Sahara, has to protect the right of the Sahrawi people to freely dispose of their natural wealth and resources, and must, in any case, respect that the people are not deprived of their means of subsistence, according to the articles that we are discussing today. Under international humanitarian law 2, the exploitation of natural resources can only be used to offset the cost of occupation under the principle of usufruct. So this was the theory. In reality, Morocco seems to be plundering the wealth and resources of the Sahrawi people. For example, I'll just give one example, a large Moroccan state-owned company exports phosphates from Western Sahara. In 2016, some Sahrawis conducted a hunger strike to highlight alleged discriminatory hiring practices by this company, hiring only Moroccan settlers in the Western Sahara. In so doing, it violates the 4 fundamental labor rights of non-discrimination at work, as well as Principle 4 of the United Nations Guiding Principles on Business and Human Rights. Now, one might wonder whether companies, privately or publicly owned, can, überhaupt, respect human rights in the Western Sahara. According to the European Commission, they can, and they could bring plenty of benefits to the Western Sahara. For example, in January of this year, the Commission alleged that trade agreements between the EU and Morocco that cover the Western Sahara without Sahrawi consent have contributed to maintaining dialogue and constructive cooperation on human rights. While it is certainly true that businesses bring plenty of benefits to Moroccan settlers who undertake business in the Western Sahara, it is not true that they bring such benefits to most of the Sahrawi people. Scholars and civil society organizations agree on this matter. So, apart from the benefits, is this even relevant? No. In September 2021, the General Court of the European Union ruled that it is not relevant whether any benefits are brought to anyone living in the Western Sahara. The yardstick should be whether the people of Western Sahara have granted their free and genuine consent. And the Article 1 that we discussed today, as already mentioned, Morocco shall promote the realization of the right of self-determination and shall respect that right. Under humanitarian law 2, Article 8 of the 4th Geneva Convention, people under military occupation cannot credibly give consent to the taking of their resources as they are protected persons. Standing in their place has a strong neo-colonial flavor. Pretending to have received consent from Sahrawi civil society organizations, as the EU has also done to save face and persist, is not sufficient. By extending the territorial scope of bilateral trade agreements between the EU and Morocco covering fishery, agriculture, etc., the Western Sahara, the EU could furthermore violate its international law duty not to render aid and assistance in the commission of an unlawful act. They are far away from the actions that would be appropriate in this instance, as the EU Global Human Rights Sanctions for specific corporations of people for systematic human rights violations. While the European Union has often adopted regulation relating to business and human rights that are very well received, the EU thinks that it does not have to stand with the Sahrawi people and ignores the decisions of its own courts. Is it out of fear? Perhaps. Perhaps if the EU stops fish, tomatoes, and melons originating from Western Sahara at the border, Morocco might stop controlling security threats and migration flows to the EU and start a territorial dispute with Spain. And the EU is not alone. Various other countries in Africa, for example, need Western Saharan fertilizer due to supply chain shortages and conflicts. This is not a nice picture, and what can we do in this room? We can start with naming and shaming supermarket chains that sell products originating from Western Sahara, and we cannot buy these goods. It is possible. In Switzerland, for example, the imports of agricultural foods from Western Sahara have been reduced drastically, almost to zero, thanks to consumer boycotts.
Thank you, Ms. Nielsen. Also to remind that there are some serious violations of international humanitarian law in Western Sahara, and also the role of the international civil society can play in supporting the struggle of. Thank you very much. And now we should have Mr. Pedro Pinto Leite, but we haven't seen him because he's in Holland, and I don't see him on the screen. So I will just pass the floor to Kathleen Thomas in New York. She is a lawyer, and she was member of the UN Identification Committee for the referendum in Western Sahara when the MUTO was created. He's also coordinator of a book just published in October 2022, titled Justice on Trial, Law, Politics, and Western Sahara. Kathleen, you have the floor.
Thank you. Can you hear me?
Yes.
Yes, good. I speak to you sadly as one whose country has betrayed the rights of the people of Western Sahara under international law from the very beginning of the conflict. If it hadn't been for the fact that the US arm-twisted Spain into agreeing to Morocco's takeover of the territory in 1975, this conflict may never have arisen. If it wasn't for the fact that the US gave Morocco massive military aid during the war between Morocco and the Polisario, the Sahrawis might have won that war. If it wasn't for the fact that the US refused to force Morocco to abide by the agreement with the Polisario it made in 1991 and allowed the referendum to take place in 2003, according to the voters list compiled by MINURSO, the status of the territory would have been settled long ago. Today, the US has continued its betrayal of the people of Western Sahara. It continues to supply weapons to Morocco, which can only be used in its conflict with the Polisario. It has failed to submit a resolution in the Security Council to expand MINURSO's mandate so that it can monitor human rights violations in the territory and the Polisario camps, despite the fact that all other modern UN peacekeeping missions have such a mandate. But perhaps the most glaring betrayal of all is that the present administration has failed to renounce the proclamation of former President Donald Trump that the US would recognize Morocco's sovereignty over the territory. Recently, the US has rejoined the Human Rights Council after its abandonment under the presidency of Donald Trump, and will sit as one of its members through the year 2024. This is obviously intended by the current administration to demonstrate its commitment to human rights. Yet it is not enough merely to join international organizations and mouth platitudes in lofty conference chambers. The US needs to put its money where its mouth is and actually put into practice on the ground the lofty ideals it so often espouses but so rarely abides by. Morocco has attempted to acquire Western Sahara by force against the canons of the UN Charter, and during its period of occupation has inflicted widespread human rights violations on its people, forcing many of them to flee the territory. Today, the US is supporting the rights of the people of Ukraine to withstand a similar attempted acquisition of territory and human rights violations by Russia. Does the US only care about such violations when they occur in Europe, or perhaps when oil is at stake? It is a question that people around the world are asking. Recently, the American Bar Association, the largest association of attorneys in the US, supported by the New York City Bar Association, endorsed a resolution which urges the President of the United States to withdraw the recognition of Morocco's sovereignty over the territory, to urge Morocco to permit the people of Western Sahara to choose freely whether to establish an independent state or agree to incorporation within Morocco, to allow the people of Western Sahara to freely express their support for independence or a referendum to determine the status of the territory, to affirm the right of the people of Western Sahara to the enjoyment of their natural resources and their right to dispose of those resources in their best interest, to use the resources of the territory of Western Sahara only with the permission of the people of Western Sahara, and if such use principally benefits such people, to continue the policy of excluding products from Western Sahara from the free trade agreement with Morocco, and to introduce a resolution in the UN Security Council that would expand MINURSA's mandate to monitor human rights violations. It also urges the US Congress to ensure that any humanitarian or military aid to Morocco included in bills passed by Congress is conditioned on Morocco's removal of restrictions on the free speech or movement of the people of Western Sahara, its willingness to permit journalists free access to Western Sahara, and its willingness to accept a solution that would include the option of independence for the territory. It further urges the US Congress to pass legislation that would ensure that all importations from Western Sahara, as well as business between the United States entities and Western Sahara, comply with international law principles concerning the use of resources of non-self-governing territories. Now that the United States is a current member of the Human Rights Council, I suggest that it would be fitting for the President and US Congress to follow the recommendations of the US legal community and to finally implement the provisions of the International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights, and to otherwise support the rights of the people of Western Sahara. Thank you.
Thank you very much, Catherine. Indeed, the role played by the US in the issue of Western Sahara is very important. And we have always to remind that the occupation of the territory by the Kingdom of Morocco in 75 was really supported by the US government, including by the CIA. And still today, about 90% of the armament, the Moroccan armament, is sold by the US. And with this, I will move. I think Pedro is with us now. Yes, he's here. So, yes. Pedro, I will give you the floor. Mr. Pedro Pinto Leite is Secretary General of the International Platform of Jurists for East Timor. And he is also coordinator, along with Kathleen, of the collective book Justice on Trial, Law, Politics, and Western Sahara. Please, Pedro.
Are you hearing me?
Yes, very
okay. Well. No, sorry, I had problems with connection with Zoom, and I have also I have a terrible cold. My voice is a little bit strange. I hope you hear me well. Anyway, you, Giancarlo, you suggested me that in my paper I could present the second book that you already said the name. Of our platform, International Platform of Jurists for East Timor on Western Sahara, and also relating this presentation to the theme of this conference. I don't know if you already mentioned the Article 1, which is common to both covenants, but is that the case? Everybody knows about this Article 1?
Yes, Pedro.
Yes?
Yes.
Okay, so I'm not going to read it. And I would like first to make some brief remarks about this article. Well, as I said, it's common to both covenants. The first consideration is that the right of self-determination is of great importance because its realization is an essential condition for the enjoyment of individual human rights and for the guarantee of those rights. It's for that reason that the right to self-determination in the two covenants is placed as apart from and before all the other rights. Another aspect to consider is the article in its third paragraph imposes obligations on all states parties to the covenants. The fact that the right to self-determination in present-day legal theory is seen as a case of jus cogens has extended these obligations to all states without exception. Also very important is the provision of its second paragraph which established sovereignty over natural resources as a corollary of the right to self-determination. Now, going to our book, whose themes, as you'll see, largely follow the content of Article 1 of the Covenants, applying them to the concrete case of the Sahrawi question. It is a joint work with 25 authors from 15 countries, 15 of whom are jurists and 14 university professors, some of whom are emeritus. As you would expect, they all know the Sahrawi question very well. Interestingly, half of them were also activists for the cause of East Timor's self-determination, with some writing extensively on the issue. For example, among the authors of our book, Professors Roger Clark, Christine Schinkin, and Lauriani Kainen also wrote chapters of the first IPJET book on Timor-Leste. And I thought I had here a copy, but I haven't. The name is International Law in the Question of East Timor. It's from '95. And the same Roger Clark and Clive Simmons also contributed to our second book on the issue, The East Timor Problem and the Role of Europe, from '98. None of this happened by chance. The issues of Timor-Leste and Western Sahara are, for international law, like two drops of water, and also present many similarities from the perspective of international relations. And that is also the reason why IPJET, once the liberation of East Timor had been achieved in '99, in reality having fully attained its statutory goals, instead of having been dissolved, went on supporting the right to self-determination of the people of Western Sahara. As I wrote in the first part of the book's introduction, the initial idea was to publish some of the presentations made in two conferences co-organized by IPJET, one in The Hague with the Stichting Zelfbeschikking West Sahara in March 2016, the other in Lisbon with the Portuguese Assembly of the Republic in May 2017, on the 25 years of our NGO.
What do you think you're doing?
The many events on the issue of Western Sahara that followed the second conference, the most important being the new cases brought by the Polisario Front before the General Court of the European Union against the European Council, made us change our plans. Some of the authors who had made presentations in those two conferences decided to write on the cases. Unfortunately, for various reasons, including the corona pandemic crisis, the book could only be published as an ebook last October and as a printed on demand 1 month later. The book was therefore published 13 months after the very important judgments of the General Court had been delivered in September 2021. The only thing we could do was mention the articles that some of the authors of this book have since published elsewhere about the trials. It's the case of Eva Cassotti, Jeffrey Smith, Carlos Ruiz Miguel, Juan Zulueta, Stefan Zuns, Jacob Mundi, and Kathleen Thomas. And it's exactly Kathleen who had already spoken before me, one of the editors of this book, the other two being the Irishman Clive Simmons and myself. The excellent title of the book was also thought of by Kathleen, Justice on Trial, Law, Politics, and Western Sahara. She and Clive had the hard work of correcting the texts of authors who did not speak English as their mother tongue, which is my case. Professor Richard Falk, who I like to call the Noam Chomsky of international law, kindly wrote an interesting foreword for the book. Like Chomsky, Richard Falk is an American Jew who holds very progressive political views and who, despite his age, maintains a daunting schedule, traveling, lecturing, and writing. In the foreword, he refers to the heroic struggle of the Algerian people for self-determination and the way in which, and I quote, the French were defeated politically, morally, and legally, despite their weaponry, international status, and control of Algerian governing institutions. As you can imagine, the case of Morocco, they will have the weaponry, they have the control of the governing institutions, but they have a very different international status. Falk also compares the struggles for self-determination of the Sahrawi and Palestinian peoples based on his long experience with the Palestinian cause. He was part of the UN Human Rights Inquiry Commission for the Palestinian territories in 2001, and from March 2008, during 6 years, he was the United Nations Special Rapporteur on the situation of human rights in the Palestinian territory occupied since '67. The book has 4 sections, 2 of which, the first and the third, are closely linked to the theme of this conference, the right to self-determination and the sovereignty over natural resources. The other 2 deal with human rights and international politics on the conflict. In the first, 7 authors analyze various aspects of the right to self-determination that apply to the question of Western Sahara. Lauri Annikainen compares the Sahrawi issue with the issues of Timor-Leste and Palestine. Rosa Clark does the same with issues of East Timor and Western Sahara. This is the 6th book with many authors with the issues of East Timor and Western Sahara that I am editor or co-editor, but it's the first in which I am also the author of a chapter, and in it I refer to the possibility of a widespread recognition of the democratic Sahrawi Arab Republic to manage to resolve the conflict. Clive Simmons deals with the issue of non-recognition and denial of self-determination in the case of Western Sahara. Hamza Sherif and Stefan Zuns write about the illegal Trump's proclamation of recognition of the sovereignty of Morocco over the Western Sahara, and Joan Sorueta about the consequences of such a proclamation. Hamza Sherif, in another chapter, deals with the illegality of the establishment of consulates in the occupied territory. In the second section on other human rights, Carlos Beristain and Francisco Gabilondo describe the discovery of 2 mass graves with 8 corpses and the identification of the corpse of a disappeared Sahrawi. Isabel Lourenço addresses the many serious violations of human rights by Morocco in the occupied territory, including cases of genocide, also referring to unfair trials, transfer of population, and the exploitation of resources. Christine Schinkin deals with the particular case of violation of human rights against women in both East Timor and Western Sahara. And Gansi Na addresses the issue of the 2,700-kilometer wall of shame built by the Moroccans, which now separates the occupied territory from the liberated territory. In the third section on natural resources, Manfred Inz deals with the first judgments of the European Court of Justice and the reaction of the European Union entities to those judgments. The text by Paul Range and Eva Cassotti explains how the European Commission successfully argued for an illegal trade agreement with Morocco. Sarah Eichmans and Eric Hagen show how Morocco's renewable energy projects in the occupied territory may prolong the status quo. And finally, Jeffrey Smith deals with the law of the sea and its relevance to the conflict. In the last section on the political issues raised by the Sahrawi question, Kathleen Thomas enumerates the pros and cons of the Moroccan proposal of autonomy for the territory, as opposed to the existence of an independent state in Western Sahara.
Pedro?
Yeah.
I should ask you kindly to conclude.
I'm very, very near the end. The title of Ia Zubir's chapter says it all, the Israelization of the Western Sahara conflict. What equivalent studies how the Sahrawi and Palestinian issues have been dealt with the UN. And Ali Alawi explains the origins and rise of Sahrawi nationalism. Jacob Mundi describes the end of the peace process and how the resumption of war was inevitable. Finally, Carlos Luis Miguel argues that the independence of Western Sahara is the only solution to the conflict and the best guarantee for the stability of the Maghreb. And okay, I'm the end. As I said before, the book is published as an ebook and in print on demand version. The printing is by the American company Ingram Spark, and in order to be read by many people, it has a very fairly low price. As an ebook, it can be purchased for about $3 or euros through, for instance, the websites of Barnes & Noble, Rakuten Kobo, Amazon, and the Australian company Booktopia. As print on demand for about $25 or euros at the same companies and others in many countries, such as ebooks in the United States and the United Kingdom, as at Walmart and Harvard Bookstore in the United States, at Kinokuniya in Japan, at Boomerang Books, of course, from Australia, Fishpound from the United Arab Emirates, Didrich from Luxembourg, and Senio from Poland. And I'm finished. Thank you.
Thank you, Pedro. And indeed, after your advice, I can only recommend to everybody interested in the issue of Western Sahara to buy this book. And I recall the title, Justice on Trial, Law, Politics, and Western Sahara. And with that, I will give the floor to Ms. Ana Miranda from Spain. She is member of the European Parliament, and she is Vice President of the Parliamentarian Intergroup for Western Sahara in Brussels. Anna, you have the floor.
Mais merci beaucoup. Je vais utiliser le français dans la conférence. Je remercie beaucoup les organisateurs. Je m'excuse aussi parce que je ne suis pas avec la possibilité d'aller à Genève à ce moment, parce que justement aujourd'hui, je suis à la commission de pêche du Parlement européen. Moi, je viens de Galice. Et je travaille pour la commission de pêche, aussi pour l'intergroupe de Western Sahara. Et justement, aujourd'hui, nous avons un point sur l'accord de pêche à porte fermée. C'est-à-dire que le Parlement européen va parler aujourd'hui à porte fermée sur l'évaluation et sur le suivi de l'accord de pêche avec le Maroc. Vous savez qu'à ce moment, la situation du Sahara occidental au sein du Parlement européen, c'est la meilleure des situations que jamais. Et malheureusement, c'est pour les cas de corruption, parce qu'avec l'affaire Qatar et l'affaire Maroc, le Morocco Gate et le Qatar Gate, nous avons dénoncé dans l'intergroupe qu'il y a une interférence du Maroc dans toutes les questions relatives au Sahara occidental. Et c'est pour cette question et ce momentum, political momentum, que nous avons la meilleure des situations pour la question du Sahara occidental. Parce qu'on a la pression, on a les évidences dans tous les cas de corruption et de manque de transparence que le Maroc a eu un lobby de mauvaise influence contre le Sahara occidental ici au sein du Parlement européen. Depuis des années et dans beaucoup de rapports. Par exemple, à la Commission des droits de l'homme que je suis aussi membre, ça fait 12 ans qu'on ne parle pas de la question du Sahara occidental. C'est terrible. On parle plus à la Cour africaine des droits et merci à l'Afrique pour la solidarité avec le Sahara. On parle aussi à Genève, mais on ne parle pas du Sahara occidental dans la Commission des droits, et si questionné à ce moment pour le cas de corruption du Parlement européen. Donc, il y a des raisons politiques. Les anciens présidents de la Commission des droits, dans les 2 ans passés, c'est une socialiste espagnole, un socialiste italien qui est en ce moment à la justice belge, qui s'appelle Panzeri. Avant, c'était Mme Elena Valenciano. Et le dernier, c'est Maria Arena, qui c'est toujours pas en justice, mais qui a renoncé à la question. De la part de notre groupe, que c'est le groupe politique Vert Aller, et aussi d'autres groupes politiques du Parlement européen de gauche, et on a défendu toujours que la Commission des droits de l'homme utilise la question du Sahara occidental comme prioritaire. Et jamais on a obtenu, dans les 10 ans précédents, une réponse positive. Donc, ça, c'est la première chose. Mais après, il y a la commission de pêche, où il y a toute la formulation de l'accord de pêche avec le Maroc qui a été très controversée et très bouleversée. Et je le dis parce que, à notre opinion, l'accord de pêche avec le Maroc, c'est une violation flagrante du droit international parce que c'est un territoire en décolonisation et la décision de l'Union européenne de donner les ressources de la pêche halieutique au Maroc, c'est une décision totalement illégale. On l'a dénoncé, j'ai ici beaucoup de communiqués de presse, beaucoup des années, en disant qu'on ne peut pas faire un accord sans le consensus, sans l'accord du Front Polisario. On a dénoncé cette question à la Commission, on l'a dénoncé au Conseil, on l'a dénoncé par toute l'Europe, et le Maroc s'est maintenu dans l'accord de pêche avec l'Union européenne. Après, en février de 2018, le tribunal européen et le tribunal de justice de Luxembourg a déclaré que l'antérieur accord de pêche n'était pas applicable au Sahara occidental en qualité du respect au droit international. Et toutes les années perdues, quand on savait bien que l'accord est illégal, et maintenant, c'est la dernière décision qui viendra normalement après l'été, que c'est la décision sur la légalité de l'accord de pêche. Et justement, aujourd'hui, à ce moment, dans 5 minutes, je m'excuse aussi parce que je devrais partir, parce que la réunion c'est à porte fermée et après, ils ne me laissent pas entrer. Et même il y a ces questions un peu controversées au Parlement européen. On va discuter à la commission de pêche du Parlement européen sur la question de la situation actuelle de l'accord de pêche. Parce que ce que veut le Maroc, c'est une prolongation de l'accord. L'accord de pêche, ça va être fini le mois de juillet. Et le Maroc fait déjà son lobby pour la continuation de cet accord de pêche. Et je pense que ce moment de la question saharaoui, de la reconnaissance du Polisario, de la dernière célébration du congrès dans les camps de réfugiés, de notre position active de l'intergroupe Sahara occidental du Parlement européen, il faut maintenir la pression pour essayer et pour avoir un bon résultat parallèle à la Cour de justice. C'est pour ça que nous allons organiser les mois prochains, les mois mai, juin, juillet, on va bien décider avec l'intergroupe, une conférence sur la situation des accords dans le Sahara occidental et vous êtes bien invités en qualité d'association. On voudrait bien avoir la présence de participants comme l'honneur d'écouter à M. Pedro Pinto-Leite, grand reconnu en Galice et aussi pour tous les défenseurs des droits internationaux du monde, aussi à tous les membres qui ont participé aujourd'hui à la conférence. Et nous allons organiser une conférence pour faire la pression aussi à l'Union européenne qu'il faut reconnaître le Front Polisario, qu'il faut reconnaître que la question du Sahara occidental, ça doit être partie aussi de l'Union européenne, dans le sens que Dans les services d'action extérieure, par exemple, il y a une unité qui s'occupe un desk office sur le Maroc, mais il n'y a pas une desk office sur le Sahara occidental. Je viens de demander cette question au M. Borrell. On l'a aussi parlé avec M. Ouvi, auquel je vais donner une salutation, notre délégué à Bruxelles, délégué jusqu'à le moment, pendant qu'il n'y a pas une autre nommée, mais il a fait un travail extraordinaire pour la défense et la maintenance de cet intergroupe. L'intergroupe du Sahara occidental du Parlement européen est composé par 4 familles politiques, par députés européens de différentes familles politiques, de toutes les nationalités. Et nous avons déjà la participation dans le COCO, dans le congrès du Front Polisario, mais surtout, nous sommes très actifs pour la question de défense des droits humains au Sahara occidental et pour la supervision des accords. Et à ce moment, c'est le moment d'être très vigilant sur ce que va faire l'Union européenne et la Commission concernant les accords de pêche. Parce que s'il y a un moment politique pour le respect au Sahara occidental au niveau de l'Union européenne, c'est maintenant. Et on veut qu'il y a un recul de toutes les décisions terribles que l'Union européenne, mais aussi le Parlement européen, un peu moins, mais aussi a fait concernant le Sahara occidental. La dernière question, c'était par exemple le prix Sakharov, dans lequel Madame Sultana Khaya s'était nommée dans la shortlist pour les finalistes. Elle a été enlevée de la liste. C'est la manque de célébration des hearings sur les questions Sahara occidental et sur la situation des prisonniers. Et c'est l'unique pression qui existe, c'est l'intergroupe du Sahara occidental. Dans le moment que la corruption et la manque de transparence évidencent qu'il y a une réseau organisé du Maroc pour empêcher aucun débat sur le Sahara occidental au Parlement européen, qui c'est très lié à la question de Qatargate. Nous avons envoyé une lettre à la présidente du Parlement européen pour dire qu'il faut empêcher les représentants du Maroc d'accéder aux installations du Parlement pendant que la question est clarifiée, parce que les lobbies qu'ils ont faits contre le Sahara occidental, ce n'est pas éthique. Et ils démontrent aussi qu'il y a des députés européens pro-marocains qui sont dans la question. Mais aussi, vous savez bien, et je vais finir, qu'on a eu toute la question sur la liberté de presse au Maroc, qui a aussi une influence sur le Sahara occidental et sur la liberté de presse en général. Et on a eu aussi la pression du Maroc pour tout ce qui empêche de parler du RIF, du Sahara, de la liberté en général au Maroc. On a 2 victoires le mois de décembre qui sont historiques. Et vous pouvez imaginer que les députés comme moi, comme mon collègue Miguel Urban et des autres collègues de l'intergroupe, on a souffert une pression énorme du service secret du Maroc. Même, on nous a dédié une session au Parlement. Mais nous sommes fiers de défendre la cause sahraoui au Parlement européen. On va continuer. On va suivre toute la pression et surtout la référence que je vous ai dit sur l'accord de pêche, parce que c'est hyper important le développement qui va faire la Commission européenne jusqu'à le moment de l'arrêt de la Cour de Luxembourg. On imagine que ce sera le mois de septembre ou octobre. Donc, je laisse ici mon intervention pour donner mon support au peuple sahraoui, le support de notre groupe, le support de l'intergroupe et surtout la possibilité qu'on aille cette réunion ici à Bruxelles au sein du Parlement européen dans une conférence multiple qui peut continuer à faire ce travail que vous faites si bien dans cette conférence et cet événement. Merci beaucoup.
Merci beaucoup, Anna, pour ta participation à cette conférence. Et on te laisse partir vite à la réunion en porte fermée avant que les portes soient fermées. Et merci beaucoup aussi pour tout le travail que vous faites à Bruxelles. À bientôt. And now I will give the floor to the last but not least speaker, His Excellency Mr. Uri Bushraya, Minister for Europe, of the Sahrawi Arab Republic. Ubi?
Yes, good afternoon, everybody. Okay, thank you, Gianfranco, and first of all, on behalf of the people of Western Sahara and the leadership of the Polisario Front and the government of the SADR, I would like to thank the Geneva group, both at the level of the representatives of the states, of the friendly states of Western Sahara, and their ambassadors, whose agenda is always very busy. We know that the agenda, the multilateral agenda in Geneva, that is very, very demanding, and the ambassadors are very busy, but yet they always found the time to work for the Sahrawi cause and make sure that the Western Sahara and the struggle of our people is always at the center of the debates at the level of the UN Human Rights Council, but also at the various and different UN agencies. Also at the level of the NGOs, the one that you are chairing, Gianfranco, and that also the NGOs and the group of NGOs that they speak regularly on a regular basis to address also letters to the UN and other international forums to unveil the atrocities that Morocco is committing on a regular basis against our civilians and their occupation. So it's really, we commend you on this work, both the Geneva group, both at the level of ambassadors, but also as at the level of NGOs. We know that it's not an easy task to defend the Sahrawi cause within the UN system. Sometimes it appears to be a sort of David versus Goliath in a way, but we think that now gradually the world is discovering the real face of Morocco, not only as an occupying power, not only as an oppressor, a country that is violating the international law everywhere, but also a real rogue state that is making use of all sorts of unlawful methods to consolidate its occupation of our land. And Geneva, you would all recall that Geneva has been and still a center of or a theater of the continuous actions committed by Morocco to sideline the right of the people of Western Sahara since the Chris Coleman emails and stories that they have been revealed, and since the challenges that you are facing almost on a daily basis to bring the issue of Western Sahara to the interest of the people at the level of the Human Rights Council. Morocco Gate is just the most recent scandal where it has been confirmed so far the implication of Morocco on putting in place a machinery to corrupt the European members of the parliament in order to silence the Sahrawi people struggle, but at the same time also to undermine the EU Court of Justice decisions. Our sister Ana Miranda spoke on the efforts that she's doing within the European Parliament intergroup on Western Sahara, and I just want to seize also this occasion to commend the intergroup and to commend them really on the good job that they are doing, especially in this very interesting moment. Africa also, and the colleagues from South Africa, they have preceded me to speak, and they would have noticed that Africa also is not far from this corrupt machine Morocco is making use of. Africa has been placed also at the center of this corrupt diplomacy with one central objective, which is to influence the position of the SADR within the African Union. The recent appeal, the so-called appeal of Tangier, that is aiming at influencing the position of the SADR within the African Union, is just the African version of the European scandal, Morocco Gate. And to conclude, in Western Sahara, we are at a sort of crossroads momentum. Whether we go to a further escalation, because the war is going on since November 2020, or we go to a peaceful solution. And that peaceful solution, everybody knows what is the nature of that peaceful solution. It's exactly the plan that has been agreed between the two parties, Morocco and the Polisario Front, in 1991, to allow the people of Western Sahara to exercise their right of self-determination. That's the only option that could grant a lasting peace in Western Sahara and in the whole region of the Maghreb. The Sahrawis, we are more determined than ever to pursue our struggle for our inalienable right to self-determination and independence. And thanks to your support, to your commitment and determination, certainly Western Sahara will be free very soon, and the whole of Africa will be decolonized once for all. I thank you very much.
Thank you, Minister Bouchraya. Now we have just a few minutes left. So I don't know if there are anybody wishing to raise a question or make comments.
So I'm here for.
You can introduce yourself.
Yes, so I'm actually youth family human rights activist, president of Association des Études. I'm living on the Syrian military occupation and teaching on to understand the pain of Sahrawi people. As you, I want to take the opportunity to ask how we can implement ICCPR and ICESCR nations like Sahrawi Tamil living under military occupation and white treaty bodies that don't want specific information on the occupations. I think that sometimes people comment, but probably not enough.
Thank you. Anyone else? If this is not the case, yes, please. Michael? Le micro, le micro.
L'Union européenne est unie sur la question de la pêche et j'aimerais simplement vous signaler un rapport de la Commission européenne qui est paru le 13 janvier 2023. Je pourrais vous en donner encore les chiffres, et qui est un document de travail pour la Commission. Et en fait, ce document de travail est extrêmement intéressant parce qu'il montre que d'une certaine manière, il part du principe que le fait d'avoir analysé les ressources naturelles sahraouies et locales qui sont exploitées, eh bien, cela fait que l'on vend davantage de produits sahraouis locaux. Il n'y a plus de douane entre l'Union européenne et l'Europe. Et on se rend compte, en fait, que tout cela très intéressant de lire la façon dont est écrit ce texte, parce que en première page, on vous dit rapport 2022 sur les effets et avantages pour le peuple du Sahara occidental en ce qui concerne l'extension des préférences tarifaires aux produits originaires du Sahara occidental. On vous dit effectivement que on en a vendu davantage, donc c'est très bien. Et si je crois qu'on n'a pas parlé, juste là, quand même, on vous dit de vous présenter. Eh bien, si on prend production de produits agricoles au Sahara occidental, la région, c'est en 2020-2021, dans la région de Dakhla, eh bien, on aura les tomates, une représentation c'est là. Eh bien, il y a eu 55 200 tonnes de tomates sont parties. Quelle est la valeur de cela? Bien, c'est autour de 55 à 60 millions. Et puis, si l'on prend, par exemple, l'exportation de produits de la pêche vers l'Union européenne, donc uniquement ce qui provient des oui. Eh bien, on va avoir, si vous voulez, de façon totale, je ne vais pas vous dire la description de tout ce qu'on pêche, c'est absolument dans ces eaux territoriales. Eh bien, les captures totales, la région de l'Ayoun et Sakia et Lamba, le volume était de 380 tonnes. Et puis, dans la région de Dakhla, au sud, 470 100 tonnes. Et la valeur en millions d'euros, première région dont je vous ai parlé, 196 millions d'euros. Et la seconde région, 294 millions d'euros. Vous voyez en fait ce que représente le pillage du Sahara occidental, s'agisse effectivement de l'agriculture, des tomates en l'occurrence, je n'ai pas voulu donner d'autres, et puis de la pêche. Il me semble que ce document est très important pour nous, de façon à voir, d'une part, comment l'Union européenne lire à ce document, que tout cela est très bien. Et puis, en fait, on assiste à un pillage organisé et on espère que justement la Cour de justice européenne en automne quand les accords on voit que toute le pillage enrichit le Maroc sont extraordinaires.
Thank you. Indeed, this document that has been published by the European Commission last January is just a way to justify why they circumvent the European Union Court of Justice decisions on the agreement between the European Union and Morocco. And if anyone is interested in you can just ask us and we will send you the document. One else wishing to make a comment or there's a question, please.
Thank you. Then Dango, Director General of the Corporation of South Africa. Quick one, all the speakers are basically just underlined the fact that occupation is not an allegation. That there's breaches of international law when there's a common article of this breaches of this Goldman's norms, what extent then should we be able to hold accountable for specifically the international regulations, articles of acts which might have understanding this viable? What extent can we use council and other when aspects?
Well, the issue for us is also from the beginning, the issue of Western Sahara was dealt with in the Organization of African Unity and then African Union. So for the last years, the African Union is not anymore part of the process in the security. And this is very worrying. Now, there is this issue of many African opening consulates in the occupied territory, which is completely illegal. So the question maybe for you, if I may say, as a countries, is to see how to deal with this issue. Put down kind of consulate. And of course, at the European Union level, as the go say, we just wait for the decision at the end of the year, hopefully, the final decision of on these agreements between the European Union and Morocco. And hopefully, with all these issues of corruption, the European Union Parliament and maybe Commission, the perspective also of European countries may change. I don't know if there are any other questions or comments. If this is not the case, I close the conference. I thank you very much, all of you, for your participation, and all the panelists of the conference, the Deputy Ministers of South Africa for International Relations. Thank you very much.